Welcome to today's webinar, Consumer Financial Services Outlook 2023. This is Jonathan Pompan of Venable, along with several colleagues that work day in and day out in consumer financial services issues and matters across the country on a variety and a diverse amount of topics. We're coming to you live today with a tremendous amount of content and highlights of what's happening in and on the horizon in the consumer financial services law and policy areas. Now, we have some important information, though, before we begin. And that information, though, is that this session is going to be recorded and available on our website later this week or early next week. We also send out a push email to everyone with the content that's RSVP'd, as well as also for attendees today. Now, we want to thank you for joining, and of course, we encourage the use of the webinar platform to ask questions. We do read every question. We try to get to as many as possible during the course of our webinars, but sometimes we're not able to for a variety of reasons. So if we're not able to work in an answer in the course of the discussion, please recognize that we will get back to you offline outside the context of the webinar. Now, of course, this presentation is not legal advice. It's not intended to be specific to any particular company, so please don't share any information that might be confidential or otherwise proprietary with respect to your company. And of course, we're happy to discuss at any time how we might be able to help you. Now, also, today's session is going to be offered for CLE. And with respect to the CLE, of course, we will be sending out an email with the information after the session. And during the course of the session today, we're going to have a code that we'll give about halfway through, as well as at the end of the session for live attendees. And, of course, if you have any questions about the CLE, please feel free to email those to the contact information that's been provided in the emails that you received when you RSVP'd for the session and got the login today. So we know there are no shortage of developments on the horizon. The developments are diverse, anywhere from a divided Congress and the legislative landscape to the future of the CFPB, which is really facing existential threats, given some court developments in the last year, some of which you may have heard about already and which we hope to update you on today. There's also hot topics and trends where we're trying to consolidate and synthesize a number of different topics in a couple key areas of interest to us and likely to you. We're going to cover consumer privacy and data security, as well as also supervision and enforcement, which of course permeates consumer financial services on the federal and state level, with the CFPB in the lead, and of course many organizations falling under a variety of state supervisory schemes. Talk about state developments as well, and then do a Q&A if there's any time left, as well as also questions from you. But we do encourage questions at any time, and we welcome that opportunity to answer those questions. Now, our goal with this annual outlook, as it always has been for when we started about 10 years ago and have done about 10 of these now, is to share our knowledge and insights with you and hopefully give you a better idea and context for what's happening in the broad sense of consumer financial services law and policy to connect some dots and place items on your radar. Now, we also know there's a mix of generalists, specialists, and folks that may be transitioning into new roles and those that are established. We also know that many of your clients, your companies, are probably undergoing some changes now in a variety of different ways, and probably always have been evolving and engaged in a multitude of different activities and things that are on the drawing board that implicate financial services, policy, and legal developments. So we're excited to share our knowledge today with the diverse and multidisciplinary approach that the folks here at Venable give, and that you're an audience that has allowed us to grow with you and that you've grown with the consumer financial services space. The issues and challenges continue to evolve, and we really appreciate the opportunity to bring that to you. Throughout all of it, it's been a lot of fun to be able to present these types of sessions, and we try to synthesize and consolidate as much as possible in the short period of time that we have. So, we love to counsel. We love to be involved in the communities that we're working in. And I know that our colleagues, the folks on our team, including the panelists today, really enjoy the opportunity to work on the diversity of the issues that we're going to be covering on the full life cycle of credit and debt, law and regulation. So without further ado, time to introduce our panelists and give everybody an opportunity to say hello, and then we'll work on into a divided Congress in the legislative landscape. So Ellen, welcome. Ellen's co-chair of our financial services group here at Venable and a key player in our payments work. Ellen?
Hello, everybody. Thank you. Happy to be with you today. And yes, as Jonathan said, I cross the financial services space with consumer protection and also a longtime member of our advertising and marketing group here. Andrew?
Yep. Thanks, Ellen. Happy to be here as well. I work primarily in the financial services space where I work with banks, payments companies, and other fintechs on regulatory compliance and business counseling type issues. Michael?
Hey, everybody. Mike Resnick. I am a partner in Venable's DC office, and like Andrew, I represent banks and financial institutions and other entities, primarily in the compliance area and investigations by DOJ, CFPB, state AGs, CFPB, FTC, and so on. I spent 10 years at the Department of Justice as a federal prosecutor, including the last 2 as the executive director of the Financial Fraud Enforcement Task Force. Sarah.
Hi, I'm Sarah Donovan. I'm a senior policy advisor in the legislative practice group. Chris Scribner and I, he'll introduce himself later, work a lot on financial services issues and have a variety of clients, and we look forward to talking to you today.
Hi, folks. I'm Len Gordon. I lead the advertising and marketing group here at Venable. I spend a lot of my time defending FTC, CFPB, and state AG investigations into companies that are involved in consumer financial services, have a bunch of litigation going on right now with the FTC and the CFPB, and look forward to speaking with all of you further today. Alex?
Hi, everyone. My name is Alex McGarris, a partner in our New York office as well. Like Len, defend companies in government investigations, including the Federal Trade Commission and CFPB, and do a lot of compliance counseling in debt collection and other credit-related verticals.
Hi, Chris Scribner. I work with Sarah in our legislative practice, representing financial services firms and before Congress and in executive branch agencies.
Hi, I'm Christopher Boone. I'm counsel with Venable in the DC office. I'm in the financial services group, primarily focusing on cryptocurrency and blockchain matters, money transmission and Bank Secrecy Act regulation, as well as payments regulation more generally. Harley?
Hi, everyone. I'm Harley Geiger, and I'm a counsel on Venable's cybersecurity team within the privacy and data security group. And I counsel on cybersecurity regulatory developments, security incidents and breaches, and cybersecurity compliance in multiple industry sectors, including financial services. Catherine?
Hi all, my name is Katie Marshall. I'm an associate in the Privacy and Data Security Group based here in DC. My practice focuses on compliance, investigations, and policy developments related to privacy and the financial services industry.
Thank you, everyone. And this is a really established, a terrific panel. And of course, all our key members of our consumer financial services group work with many of you. Many of you know them. Many of us know you. And we look forward to presenting today. So, you know, the first topic, of course, is the one that has been really in the news for the last week and a half and probably since November, the divided Congress, as well as also the legislative landscape. Now, when political pundits and others think about and talk about what's happening in politics and government, oftentimes divided Congress comes with the concept of great promise, but also the potential for great peril. The consumer financial services sector, of course, is by far no exception, but certainly, you know, we're used to over 10 years of essentially congressional delegated authority to the CFPB, which has really broad scope and broad authorities to do regulations in a multitude of areas that used to be areas where Congress would have had to have legislated. Nonetheless, though, and perhaps more than ever, this year and this coming Congress, the 2-year period, is going to be key for the future of consumer financial services, and certainly, as we'll hear a little bit later, the future of the Consumer Financial Protection Bureau. So with that, I'll turn it over to Chris and to Sarah. And Chris, we'll start with you. Thank you.
Yeah, thanks, Jonathan. We tend to focus more on peril than promise sometimes in our views of Congress, but we're always hopeful. I think when we, just to boil it down, the upshot of the 2022 midterm elections, left us with divided Congress, despite, in a sense, a historically poor performance by congressional Republicans who were able to take a slim majority in the House of Representatives. But when the Congress, which Senate controlled by Democrats, and the president and presidency are in different parties, it's really hard to pass legislation, and in a kind of modern Congress where passing bills is difficult for a range of reasons otherwise, but now, particularly difficult. And what that means is the administration or the executive branch agencies, tend to have more authority because they're in some ways going to be checked less, or at least checked less by legislation. Sarah will talk a little bit about how the House will be active in oversight and what the implications of the narrow Republican majority are for government.
Thanks, Chris. As Chris mentioned, I'll flip it. I would say the Democrats had a historically good performance since 2002. No president's party has done as well as they did. So as Chris mentioned, the House is a bit of a mirror image of the 117th Congress that just wrapped up. So a very narrow, slim majority, bit of an unwieldy majority, which we already saw last week with the election of the speaker. But what it means is a slim majority is still a majority in a couple ways. One, aggressive oversight is going to look the same regardless of what the margin looks like. And two, as Chris also mentioned, the Biden's legislative agenda kind of comes to a grinding halt because they are, a backstop. So if the party remains together, which they would on something like that, then they're able to stop things that either come over from the Senate or not take them up, or anything that the president would hope to push through both chambers becomes a lot more difficult. Jonathan, I don't know if you want to advance it to the next slide. We can talk a little bit more about that. So in terms of what's going to happen the next 2 years, which is the length of this Congress, essentially the Republicans will try to deny President Biden any major wins while conducting aggressive oversight. And that's going to complement the eventual messaging for the presidential campaign. And they've already been pretty clear about some of the things they're going to take up. McHenry has said as recently as yesterday that they're going to be looking at greater oversight over the agencies, including the SEC, the CFPB, and the Federal Reserve. They want to look at some of the way that Biden is approaching the economic policies. And so they've been pretty aggressive in their messaging already in terms of oversight. In terms of their majority and what we saw last week with their speaker race, it's a little bit of unwieldy. And that's because the House Freedom Caucus has exerted a lot of leverage already. And in turn, they were able to have members placed on specific committees of jurisdiction. They were able to get some subcommittee chairs, and they were able to get people placed on the Rules Committee, which controls the floor. So there's going to be discrete areas of bipartisan agreement that could come up in committee, and we'll talk a little bit about that later. But overall, it's going to be a bit of a populist bent in terms of oversight, focus on quote unquote woke capital and the ESG industry, and some other issues that we'll talk about on the next slide. Chris?
Yeah, the Senate, as we talk about the issues, the Senate still has now has a 51-49 Democratic majority. One implication of that is it's a bit easier, and there will be a few cases where the administration will be able to get its nominations done more easily because they can't be, there's not a 50-50 in the banking committee. Although, as we saw an announcement from Janet Yellen, she said that she's going to stay for the entire term. So that's one where what might have been possible to have a new nominee. From a policy perspective, obviously very difficult to pass legislation. Banking Committee Chairman Sherrod Brown has suggested that he wants to focus on housing, consumer banking issues really related to payments. Zelle, as one example, was a focus of the committee when they had the largest big bank CEOs. Most of the focus was on consumer banking and on payment. And so with Elizabeth Warren keeping that issue front and center with letters to various banks and networks, as well as to the CFPB, we can expect a focus there. But again, the focus or the effort is as much to force the agencies, the CFPB in this case, to act and not on passing bills. Cryptocurrency and digital asset policy is one aspect where we've seen bipartisan proposals in both the House and the Senate, or at least a bipartisan draft around stablecoins in the House Financial Services Committee. But so, there, in addition, will be work done in the Senate Agriculture and House Agriculture Committees because of their control or oversight of the CFTC. So we'll see some efforts on cryptocurrency as a potentially as a place of bipartisan activity, but whether or not bills can be passed will be a challenge. Another place where there's an overlap between the Senate efforts or congressional efforts and the regulators is climate policy or ESG, governance issues with the SEC at work about potentially finalizing rules in April. But a big focus of Senate Republicans, who will now be led in the banking committee by Tim Scott from South Carolina, who has not really been an active member of the banking committee. So it'll be interesting to see how he serves as a counterbalance to Sherrod Brown, but kind of focusing on anti-ESG or woke capitalism, as the kind of lingo is, will be prime concern for Senate Republicans as well as House Republicans. So Sarah, back to you to kind of close up on a couple of the core issues that the House Financial Services plans to focus on.
Sure. One thing that we spoke with McHenry just yesterday about was data privacy and changes to GLBA. Now, Katie and Harley are going to talk more about that issue in more detail later on, but that's clear that his discussion draft that he released last summer is going to serve as the basis for what they said was almost an immediate reintroduction and movement on that bill, on that issue. So I think it's interesting that while the Energy and Commerce Committees got a lot of press and airtime on their privacy bill, which will focus more on FTC jurisdiction, the House Financial Services Committee is definitely going to be taking up the issue. We're going to be hearing a lot more about that from them. I think that is something to keep an eye on because they feel that that's an issue that's right off the shelf. And again, as it relates to CFPB, as I mentioned just a little bit ago, oversight. Just yesterday, the incoming chairman put out a press release hammering the CFPB on its on the non-bank registry. So I think there's just going to be a lot of noise regarding that agency, and I think that topic is going to segue right into the next section. On talk a little bit more about the CFPB and what we could expect from them in the next couple of years.
Yeah, and not only the next couple of years, but really even this year, the real question is going to be, in many respects, what happens to the CFPB, given what happened towards the end of last year with a Fifth Circuit decision, which calls into the question the validity of all of the actions and authorities of the CFPB, bringing a case now that may go to the Supreme Court. And to talk more about that, Len Gordon and others on the future of the CFPB in light of the Fifth Circuit decision.
Thanks, Jonathan. So there's a debate about whether there will even be a CFPB going forward. How did that happen? Well, the Consumer Financial Services Association is a small dollar lender trade association, and it challenged the CFPB's payday lending rule in 2017, or enacted in 2017. They sued to invalidate the rule. Two principal challenges. One, that the rule wasn't administratively justified. It was arbitrary, capricious, sort of APA type arguments. But then it also made an argument that the CFPB receives its funding in an unconstitutional manner because the CFPB is not funded directly by Congress. The district court granted the CFPB's motion to dismiss, and it was appealed to the Fifth Circuit. And I'll read from you the beginning of the opinion from the Fifth Circuit because it gives you a taste of how they approach this issue. An elective despotism was not the government we fought for, but one which should not only be founded on free principles, but in which the powers of government should be so divided and balanced as that no one could transcend their legal limits without being effectually checked and restrained by others. In particular, as George Mason put it in 1787, the purse and the sword ought never to get into the same hands. Well, according to the Fifth Circuit, because the CFPB has this unique funding structure and has vast enforcement and regulatory powers, the purse and the sword are in effect in the same hands, and that violates the appropriations clause of the Constitution. The funding of the CFPB and its unique structure was not done accidentally. It was a core part of Dodd-Frank, the notion being to insulate the Bureau from political pressures. Part of those political pressures and the removability of the director already went to the Supreme Court, and it's likely that this other aspect of the CFPB's structure will now end up there again. So under this Dodd-Frank Act, the CFPB is funded by transfers from the Board of Governors of the Fed, which in and of itself is not funded directly by Congress, but funded by fees. So this sort of double insulation that the CFPB is funded through was a key factor in the Fifth Circuit's decision because the Fifth Circuit found that it was unique. And the funding is unique. Unlike other federal agencies, if the CFPB doesn't burn through the money that's requested and received from the Fed, it just keeps it. It has its own separate bank account, which is unlike most other federal agencies where at the end of the year, if there's any money left over, it just reverts to the public fisc. So we get the next slide, Jonathan. So the court found that Congress's appropriation power was important, and that the unique way that the CFPB was funded here violated that because Congress essentially had no control over the vast power, and the words vast power and broad powers are repeated consistently throughout the panel's opinion. So all right, so the agency is unconstitutionally funded. What does that mean? The last time the constitutionality of the CFPB went up, they just changed the removal provisions. The director is now removable at will, and that was cured. But here, the Fifth Circuit found that unconstitutional funding could not be so easily excised from the statute. They noted that the CFSA or any plaintiff would have to show that it was harmed by the unconstitutional funding, but the court found that that was very straightforward here because the rule was a direct result of the funding. It's the only way the CFPB could have promulgated the rule, so it invalidated the payday lending rule. Jonathan, can you go to the next slide? So what does that mean for the CFPB going forward? Well, if the opinion of the Fifth Circuit were to become the law of the land, right now it's the law of Texas, Louisiana, and Mississippi federal courts, but if it were to become the law of the land, the CFPB would have to cease to exist. They couldn't fund janitors, lawyers, websites, anything, because all of that stems directly from funding. Anyone who was subject to an examination could seek to block that. Anyone who was subject to a rule could seek to block that. Litigants could seek to have the litigation against them dismissed. So when the decision first came out in October, there was a lot of discussion about, how would the CFPB proceed? They were clearly going to appeal this, but how? Were they going to seek rehearing en banc, or were they going to go directly to the Supreme Court? Were they going to seek reconsideration? And we learned a couple weeks after the decision that they were going to go right to the Supreme Court and seek to have the matter heard on an expedited basis. They wanted the matter considered at the Supreme Court's January 6th, 2023 conference. That didn't happen. The responses to the CFPB's petition for a writ of certiorari are now due tomorrow, January 13th. The CFPB has asked, the Solicitor General on the CFPB's behalf has asked that the petition be considered at the court's February 17th, 2023 conference, and asked that the matter be then ordered for expedited briefing and hopefully argued in April of this year. The Trade Association, the CFSA, is supporting the petition, but resisting the expedited treatment. They want to also appeal the merits, if you will, of the Fifth Circuit's decision, rejecting their administrative challenges to the rule, and also noting that they want to do even more historical research supporting their interpretation of the appropriations clause. So we'll see. We should learn soon, probably middle of next month, what the Supreme Court's going to do with this. There is clearly a circuit split. The DC Circuit has viewed this differently. District Court in Illinois a couple of weeks ago viewed this differently. And given the importance of whether a federal agency can continue to exist, it seems very, very likely that the court will take the petition. Whether it does so on an expedited basis remains to be seen. But what does this mean for companies that are dealing with the CFPB on a regular basis? So for litigants in the Fifth Circuit, I think almost all of that litigation has been stayed. The CFPB's case against MoneyGram, which is actually pending in the Southern District of New York, has been stayed, but the CFPB's case against TransUnion, which we'll hear about in a little bit more detail, was not stayed, and the judge in the Northern District of Illinois rejected the same arguments that the Fifth Circuit accepted. So it's a little bit of a mixed bag. Some litigants are seeking stays, some litigants are filing motions to dismiss. The CFPB has generally agreed to stays when they think they might lose on the merits of the constitutional challenge. It's going to be fascinating to see. There has been talk that there might be a congressional fix to make the funding of the CFPB subject to congressional appropriations. Whether that happens or not, who knows? When the FTC lost its equitable monetary relief, there were authority in the AMG case 2 years ago. Everyone thought Congress would fix that quickly. That never happened, and the FTC has been able to get around that. But here, this is not something the CFPB can get around, and the dissolution of the agency would really cause a lot of dislocation in the consumer financial services industry and some uncertainty. So whether Congress will act before the Supreme Court rules to just change the structure of the agency is unclear, or whether they'll have legislation ready in case the Supreme Court rules with CFSA, again, remains to be seen. But it will be interesting to say the least. I don't know if anybody else has anything they want to add to this. Otherwise, I'll turn it back to the next slide.
Yeah, just briefly. Len's right. Certainly, any case brought in the Fifth Circuit, I think the CFPB is pretty much toast at this point. Barring what the Supreme Court does. they can't operate without funding. They can't do an investigation. They can't supervise anything. They need that funding. And if the funding is unconstitutional, then any activity flowing from that would be, so-called fruit of the poisonous tree. There's nothing they could do to make that subsequent activity constitutional. But, you see from this map, it's a big country. You got a lot of other circuits. I'm pretty sure you're not going to see the CFPB file any action in the Fifth Circuit until the Supreme Court weighs in on it. I think if you're a company that's facing an investigation now, you've got some things to think about. I mean, if it's a bet the company case, maybe what you do is you file a declaratory judgment action. If you can in the Fifth Circuit, if you've got venue there, do it. If otherwise you're sort of taking a risk. You don't really know what the other circuits are going to do. They all operate independently. But in the meantime, the CFPB is still operating. I mean, you saw the big settlement with Wells Fargo last month. I mean, there are companies that aren't willing to take the risk of litigation. I mean, there are always risks with litigation. You don't know what a court's going to decide, especially outside the Fifth Circuit at this moment. So, CFPB is still marching on, and they're doing the best they can. And if you're a company facing this, you've got, a lot of things to think about.
Yeah, that was great points, Mike. Two other quick points. Whether companies can challenge the constitutionality of an administrative agency's actions before that action is final is an issue that's right now before the Supreme Court. So that's in the Axon case. So that'll be, and the Supreme Court appears to be sympathetic to that argument. So companies do have a little bit more grounds to file declaratory judgments, and if they can figure out a way to tie themselves to the Fifth Circuit, you'll see that. But one question will be, if the Supreme Court rules that the CFPB is funded unconstitutionally, what happens to all the cases that were already filed? Now, my view of things is that for settlements, those are compromises, those are contracts, and courts will be highly unlikely to undo them. But for litigated judgments, you would expect that there will be some effort to undo those judgments because they were brought by the agency in an ultra vires way. So we'll see what happens. But the Supreme Court's decision could unleash a tidal wave of tumult in previously litigated cases.
I like that, a tidal wave of tumult. I like that's very good.
Mike and Len, thank you very much. And, folks, stay tuned, certainly to the news possibly tomorrow with regard to the writ. And then also between then, if it is granted and heard, between then and April, and then presumably possibly a decision by June at the end of the term. But remains to be seen. A lot of different aspects and angles to this, and certainly for certain companies, a lot of potential opportunity for pushback that maybe they didn't have earlier. So with respect to hot topics, our first one is fintech partnerships and the cost of banking. Both the CFPB and the states have remained very active with respect to bank partnerships, angling and also suggesting that certain activities that may increase the cost of credit or banking services to consumers are either per se violative of a particular statute or licensing scheme or usury rate, or generally just putting the microscope on it. Now, here we highlight a couple. Certainly there are many others, but out in California, the DFTI and a fintech lender are at odds over whether or not the state usury rate and licensing applies to the bank partner that has been very active in that state with consumers, with a loan program, and really puts into question whether or not states can impose a predominant economic interest test and whether or not that's even appropriate. In the case in California, the CFL licensing scheme is one that had been applied very differently up until recently, and the DFTI has been suggesting in its court briefings and reading between the lines that when looking at the predominant economic interest, they believe that the fintech partner is actually the owner of the loans and the maker of the loans, the true lender. Now, of course, everyone on the other side there disagrees, and that's something that has been briefed, but is still pending litigation out in Los Angeles. So stay tuned there. It could have widespread sweeping impacts across the country, much like the Colorado Avant litigation had a number of years ago. The CFPB is also scrutinizing competition, scale, and technology in consumer finance, and we certainly have seen that in speeches and in other the bully pulpit actions by Rohit Chopra. And in particular, he's called into question even the back office service providers that provide functionality for account management and other services for community banks, and has done this in some other contexts as well. It's something that isn't, subject to a specific rulemaking or any particular action to date, but it is something that they've been putting under the microscope and drawing attention to. And we do think that in 2023, it's something to keep your eyes on, particularly if you're a service provider or use service providers for a big portion of your activities, how that's fashioned, as well as also whether or not you have to answer any questions about it and substantiate the basis for using those services could come into question. And then bank partnerships are also getting a closer look, and we think are going to continue to get that closer look by the CFPB. Of course, in last year, in 2022, there's been statements made to that effect, and we think that's going to continue in the future. Now, another place where bank partnerships are really popular, but certainly there are many others too, direct providers, in the payments and cryptocurrency area. And to do that, we turn it over to my partners, Ellen Burge and Andrew Biggert, as well as also Chris Boone.
Okay, so I'll get started here. This plays a little bit off of what Jonathan was just talking about. Is there's lots going on in the industry. There's new players in the fintech space, bank partnerships, platforms stacked up on top of platform. And so one of the key concerns that we're seeing permeating from the FTC, from the CFPB, are really a concern about intermediaries, especially in the payment space. And it, as one party contracts with another and essentially is borrowing their services to provide to end user consumers, and in some cases, end user businesses, small businesses that are now being increasingly treated as consumers. There's concern about who is really watching the shop here, who's making sure that these services are legitimate, that there isn't some nefarious purpose in these services, that there's proper due diligence and transaction monitoring and appropriate and prompt termination when that needs to happen. So that's really the concern we're watching in about these sort of intermediaries and payment intermediaries. Just to move to the FTC for a minute, the FTC is still very, very relevant, of course, in the consumer financial protection space. Even though their authority to obtain monetary relief for past conduct was hampered quite a bit back in 2021 with the AMG Capital case, they are finding ways and have continued to find ways to sidestep that. They are looking at new rules that they can enforce, or to update existing rules with more new provisions to address newer wrongs that they might see in industries like money-making industries, or even things with endorsements and testimonials. We're seeing, for example, proposed rules that would extend endorsement disclosure requirements to things like virtual reality avatars that might be influencers in the social media space. So they're keeping up with the times. They're using the tools they can. They're getting very creative. We saw a case earlier this year where the FTC applied ROSCA, which is a rule really written to protect online consumers who are shopping, but that was applied to business-to-business sale transactions. So whatever they can do, they are doing. We're still seeing also cases where the FTC and the CFPB, for that matter, are still looking at payments companies and banks as potential gatekeepers for facilitating payments for transactions that might be tied to consumer harm. The FTC had an administrative settlement with electronic payment systems back in May that was after many years of litigation, and then post AMG, they ended up with just an administrative settlement and no money, but we're seeing, certainly lots of interest there. And I think if you talk to folks at the FTC, they'll tell you that they're still very much concerned about who is facilitating payment transactions and where is the money moving. The CFPB last year also sort of re-upped its policy statement on what is a UDEP violation, the unfair, deceptive, or abusive acts and practices, and specifically calling out payment processing for fraudulent types of activities to be an unfair practice, referencing back something that a lot of us got our start in back many, many years ago now, but the $125 million Wachovia settlement, which was from 2008. So this has made a reappearance and is a little bit of a warning to banks that they're in the hot seat potentially for facilitating or turning a blind eye to bad sales. So next slide, Jonathan, please, real quickly. Just a couple of quick cases here for your reference. The CFPB had 2 cases this year, those against payments companies. Brightspeed was doing tech support payments, although I always question whether tech support is a consumer financial product or service, but I guess if not that, I guess maybe the payment processing was. And then the next one here, this one I believe was related to debt relief, student loan debt collection types of issues. So pretty impactful there. Andrew, you want to take this one?
Yeah, thanks, Ellen. And so, the CFPB has been focused on payments a little bit, and you can see through some of those enforcement actions. But until the last few years, it hadn't been kind of one of the primary industries they'd really focused on. But in 2022 in particular, they issued a number of different reports that really started to dig in more into the payments industry. And you can tell that they really are trying to learn a lot more, particularly on the consumer side of the payments industry, about how it works and where some of the issues are. And you can see this through reports they've issued on super apps, kind of digital wallet type capabilities that provide lots of different services, including payments, embedded commerce that facilitates payments online, for example, and then the buy now, pay later, which has obviously become a very big issue. So I think that we can expect to see the CFPB continue to try to learn more about the industry, and from those learnings, start to take action where warranted. Another development to keep an eye on, and again, it's been building for a number of years, but potentially this year, I should say, is really going to take off our faster payments. FedNow, which is the Federal Reserve Bank's faster payment system, is expected to finally launch this year, which will provide kind of real-time payments. There's already other systems like that in operation that either compete directly or kind of compete indirectly with this new service, including the RTP network, which is already in use. And then the card brands have come out with their own push-to-card services, which are used to kind of speed up and facilitate payments where you can push money right onto somebody's debit card account, for example. So I think those are going to be a big change to watch this year. Faster payments always raises potential risks of fraud, and particularly in the area of P2P. That's an area that's getting a lot of scrutiny right now. I think Chris Scribner mentioned at the beginning of this presentation in terms of some of the areas that Congress has been looking in, and fraud in the P2P payment space is certainly a big aspect of that. A lot of these systems are set up so that once a payment is sent to someone, it really can't ever be pulled back. So if you're a consumer and you're tricked by a fraudster to sending money to them, oftentimes that money is never going to be returned and can't be obtained. So there's a lot of concern in Congress about that from a consumer protection perspective, view that maybe some of the existing laws that are out there governing electronic transfers don't necessarily apply. And so the CFPB is obviously looking into that, and Congress is encouraging them to do that as well. Ellen, back to you, I think.
Okay, so a real quick note on subscriptions and recurring billing. So this is the perfect storm of payments issues meets consumer protection and advertising and marketing, but think about everything you buy now that is a subscription-based service and highly regulated under federal and state law. The FTC's got very specific rules for selling these types of products and services online and over the phone. State laws have even more aggressive requirements, and We see the CFPB is very much interested in subscription-based programs. We're going to get to the TransUnion case in a minute, which includes some of these issues. And it's a huge class action breeding ground for new cases and very expensive settlements and headaches. So if you're in these areas at all, you really need to make sure you're talking with counsel to get aligned with all of the newer requirements. We had always talked about privacy laws being a patchwork of different things. Now we are seeing the state automatic renewal laws being a lot of different things, especially when it comes time to giving notices of renewal and then timing requirements and what's acceptable forms of cancellation, some really detailed nuanced things here. So just that note there, and I think we'll move on to the next slide.
So the most significant development in the cryptocurrency industry has been the collapse of numerous cryptocurrency exchanges, including those with very significant volume. We also saw the collapse of one of the largest stablecoins, Tether, and these developments have sparked an even greater increase in regulatory scrutiny for cryptocurrency businesses. The SEC's Crypto Assets and Cyber Unit has steadily been adding personnel and has signaled a ramp up in enforcement activity. The Financial Crimes Enforcement Network, FinCEN, as well as the Treasury's Office of Foreign Assets Control, have completed a number of notable enforcement actions in 2022, including some joint enforcement actions for measures of over $100 million. These types of enforcement actions will only kind of continue in 2023 and possibly even increase as these agencies are committing more and more resources to tackling problems in the cryptocurrency industry. Banking regulators are also continuing to warn the risks of crypto assets. Just this month, the Federal Reserve, FDIC, and OCC issued a joint statement stating that issuing or holding crypto assets is likely to be inconsistent with safe and sound banking practices. We do not expect any kind of change in this type of posture, and we'll kind of continue into 2023. On the legislative side, there is likely to be a number of bills introduced, and there is bipartisan support for some measures of kind of comprehensive cryptocurrency regulation. That said, given the kind of current congressional dynamic, it's unclear if a consensus can be reached and a new framework passed in the immediate future. Finally, the Fed is continuing its research into the risks and benefits of issuing a central bank digital currency, but the Fed has also signaled that it won't intend to issue one without clear support from the executive branch and from Congress. Andrew?
Yeah, just very quickly, I think we can expect a lot of what we just talked about to continue, a lot of innovation, payments as a service growing, digital wallets being incorporated into e-commerce more and more, and then obviously regulatory scrutiny of all these developments to make sure that consumers aren't harmed and get the benefits from them. Jonathan?
Well, and thank you, Andrew, Ellen, and Chris. As you touched on already, junk fees is something that is coming under scrutiny. And those fees are not just, the unnecessary and unavoidable surprise fees, but perhaps even in the context of the current administration and the Rohit Chopra CFPB, possibly any fees that are assessed, even if otherwise legal, depending on how they may have been presented or why they may have arisen, whether it be dormancy fees and others. So any fee-based activity, particularly ones where there is recurring payments or fees that may be assessed for a service after the initial transaction can come into play. And certainly we're seeing even echoes of this in a recent announcement, yesterday's announcement for the Registry for Terms and Conditions also relates to taking payments. So junk fees certainly in scope and something that is of interest to multiple different regulators. Now, another topic that's hot is digital technology and the anti-discrimination efforts of the administration. They, in many respects, are sort of two different sides of the same coin, represent really a expansion of the traditional legal principles into the new world of digital and electronic advertising and transactions. And as Ellen mentioned, a digital dark patterns is in focus at the CFPB, but certainly at the FTC. And it's also something that has come under scrutiny in the context of the sale of consumer financial products and services in the context of the TransUnion case that was mentioned earlier. Ellen, the TransUnion case is something that you highlighted, and certainly something that has a lot in it in terms of the presentment of fees and then how they're assessed, and the consumer flow. What were the key issues in TransUnion that you'd want to highlight?
I'm going to ask Alex to jump in
Sure.
too. So.
Sure, I'm happy to. Thanks, Alan. The CFPB, FTC, state AGs have been throwing out the term digital dark patterns a lot in their press releases. The term, originally coined by a user experience marketer, simply refers to website and app designs and features that steer consumers to take certain actions on the site or the app, such as clicking. To be illegal, however, these design features still need to be deceptive, which is a standard that has been built into case law and that the FTC and CFPB have fleshed out over the years. Unfortunately, the agencies have diluted that term to the point where it's almost meaningless. Couple of the types of design features that the FTC, for example, highlighted in its recent staff report are like design elements that induce false beliefs. So think about the common feature where there's like a countdown timer when you're purchasing something, suggesting that you only have 30 seconds, 6 minutes, whatever, to make the purchase. Oftentimes those are not based on any type of countdown at all. Second, where the way the website's designed, material information is either hidden or is delayed in terms of being presented. So think of we need to hover over something to see additional information, but where it's not obvious, where you need to point the clicker in order to get that information. Third, and the one that we've been talking about throughout this presentation, are design elements that lead to consumers purchasing something that they didn't necessarily intend to. And then fourth, features that obscure or subvert privacy choices. So think about when you're on a social media app or online, and you're prompted to give your date of birth so that you can get your horoscope. But really that information is also being used to then target ads to you without you realizing. So those are some of the common practices that regulators are focused on. Next slide, please. The TransUnion case, which was filed late last year and is pending in the Northern District of Illinois, provides a little bit more specificity around the types of practices that the agencies here at the CFPB are actually going to go after and do consider to be deceptive. TransUnion settled with the CFPB in 2017 relating to its credit monitoring add-on product. And as part of that settlement, it agreed that it would need to get informed consent from customers before they sign up for these types of monitoring products that are billed on a month-to-month basis. Fast forward 5 years, and the CFPB found that the company and a senior executive in the marketing department had violated the order by using an array of dark patterns from the beginning of the interaction with the consumer, meaning the serving of an ad, through the cancellation or the inability to cancel the product. As noted here, no, Jonathan, go back, please. The first thing that a consumer saw to get to the landing page that is featured on this slide that is caused issues was an ad that just said, get your credit score, or ads indicating that, if you don't keep up to date with your credit score, bad things can happen. And so consumers that were clicking on that get your score would end up on this landing page. And by filling out their information, they ostensibly thought they would be getting their credit score, but also if you see to the right, the offer details, they actually were enrolling in a credit monitoring product that would charge them each month to receive those services. There's not a separate button here to consent to that month-to-month fee, which was a requirement of the 2017 settlement. So the CFPB alleged that the original banner ads that just said get your credit score were misleading because they actually were leading consumers to sign up for a credit monitoring product, and that also the consumers didn't realize that they were signing up for that. And then next slide, please. Finally, for folks that were trying to cancel, next slide, please, the product, the service, that it was not easy to do so. They kept being presented with additional information about the benefits that they would lose if they actually canceled. And so it became like this circular little maze that it was hard to actually end the product. That case is still pending, and we'll see what a judge thinks about it, but expect to see more of these types of cases from the CFPB. And now I'll turn it over to Mike Bresnick, who'll talk about how UDAP is being used in the discrimination context.
Hi, everybody. All right. So 2022 was a pretty big year for the CFPB in the discriminatory practices context. For one, you see here the CFPB issued a circular basically saying that creditors could no longer fail to provide specific reasons for denying credit or other adverse actions to consumers who were seeking credit under the idea that there were various AI or complex algorithms that were preventing the creditors from offering such reasons. So just a little background, ECOA, obviously, I think we all know, prevents creditors from denying credit or taking other adverse action for discriminatory reasons, race and others. But when they do provide it, when they do take adverse action, they have to give a specific reason to the applicant explaining why. But what was happening is sometimes these creditors were unable to offer specific reasons because of their complex algorithms that were sort of responsible for ultimately making the decisions. And the CFPB is making clear in the circular that they can no longer do that. They can no longer rely on those algorithms or AI if as a result, they're unable to offer those specific reasons for adverse action to the applicants. So obviously creditors now, or as a result of the circular, are going to have to take a good look at the process for offering credit, denying credit, or any other reasons why they're taking adverse actions. And they're going to have to provide specific reasons to the applicant. And if they can't do it because of their AI, well, then they better just fix their algorithms or otherwise get a better handle on it so they can provide such reasons. The second area is here you see that they modified their exam manual to say that they would no longer rely solely on ECOA when looking at discriminatory practices. So we're all familiar with CFPB's actions in fair lending matters, the redlining cases, their pricing cases, and those have been brought under ECOA. What the CFPB did last, I think it was May, is they said that, we're going to say that discriminatory practices in non-lending areas can also be a UDAP violation. This is a significant expansion of the CFPB's authority into examining, supervising, and investigating discriminatory acts and practices. It's extremely controversial. As you can see here from the final bullet point, the U.S. Chamber of Commerce, ABA, and other plaintiffs filed a lawsuit against the CFPB. Interestingly enough, this happens to be in the Eastern District of Texas, which is in the Fifth Circuit. So interesting point here, this lawsuit was filed a month before the Fifth Circuit's decision that came out saying that the funding of the CFPB was unconstitutional. The briefs had already been filed, but the Fifth Circuit had not issued its ruling at the time the Chamber of Commerce's lawsuit was filed. So if you read the complaint, it's pretty interesting. They make several points basically saying, the CFPB can't do this. This is an expansion of their authority, unconstitutional expansion of their authority. It goes beyond what the FTC is doing with UDAP, and FTC's UDAP authority is, or CFPB's UDAP authority is modeled after FTC's, and FTC can't do this, so CFPB shouldn't be able to do it. But then their final point under their claims, they make a claim saying that, the funding of the CFPB is unconstitutional, so this rule should be completely wiped out because anything that the CFPB does now is unconstitutional because its funding is unconstitutional. Again, this lawsuit was filed a month before the Fifth Circuit's opinion in the CFSA case that Len and I talked about earlier. Well, sure enough, the Chamber of Commerce filed a motion for summary judgment in November, which is a month after the Fifth Circuit's decision in CFSA. And that funding argument was front and center. It was the first argument that they made, which is, what Len and I talked about, that pretty much any case in the Fifth Circuit now is going to talk about that funding matter. Yes, Jonathan, I see you've got a question.
No, it's another example of how the CFPB is prone to now additional attacks because of that one case where people push back. And on the other hand, an obvious area of focus during exams that the CFPB is doing.
Exactly. So we'll see where this goes. Right now, it's on a motion for summary judgment, and the CFPB filed a motion to dismiss, but that case is still pending.
Thank you. Thank you, Mike. Thank you, Alex.
Thank you.
And folks, the CLE code for today is CFS 2023. We'll repeat that at the end of the session. But just a reminder for those seeking CLE, we'll send out an email with the form and all the other information after today's session. Now, the regulatory agenda, the actual rulemakings and other activities that are happening at the CFPB and throughout the agencies is numerous. And today we're just going to highlight a handful, not all of them, and certainly if anyone has questions or an area that we're not covering, like some of the banking agencies, please feel free to reach out. But, there are over a half dozen rulemakings expected or at least announced for pre-rule activity. And we expect activity in 2023. And we're going to highlight just a few of them, including first, Fair Credit Reporting Act rulemaking. It's been announced as of just a couple weeks ago, and it was originally pre-filed in November. The credit reporting sector, both as a service provider as well as also a direct provider, sometimes of services to consumers, like the reports that were discussed in the TransUnion example, has become a perennial issue for the CFPB in many different ways. And so a rulemaking here is a real opportunity, perhaps to reset the deck, but also we're going to see, I think, a lot of the activities that the Bureau has talked about, including the credit reporting space with respect to furnisher activity, as well as also the way disputes are handled to be addressed, possibly in the rulemaking to be announced. Also, and this was a topic of a lot of discussion over the last several years, the 1033 rulemaking, which requires a rulemaking on personal financial data rights, stems from the Dodd-Frank Act. And in particular, the CFPB finally came out with a proposed rule last year in the fall. And that announcement gained a lot of attention. We have content on our website about it. But as a key matter, the rulemaking comment period is closed, but there is going to be developments probably in this next year as those comments are reviewed. The proposal includes a number of different categories and subject matter that are in scope, and in particular, a handy flow down slide as to how all the interactivity between covered banks and other financial institutions would have to handle requests for the sharing of information. Obviously has a lot of implications, both on technology use and the infrastructure at financial institutions, as well as also from a business opportunity or threat context, depending on where folks stand. We know that a lot of you are interested in that, and we have a variety of materials, as I mentioned, on our website on this topic. And also, of course, stay tuned, because this is just the very early stages of the rulemaking. There'll be additional announcements, and again, we expect that this year. Now, another topic, and this is something that gained a lot of attention towards the end of last year, is a proposal for non-bank registration for what has been termed, both in the CFPB press release and in a lot of the press materials, as a repeat offenders database, a registry where non-bank enforcement actions would be cataloged, and where in this public registry, companies would be expected to submit information. Now, what is unique about this is it's not actually confined solely to repeat offenders. It, in fact, actually would be first-time offenders. Perhaps the repeat offenders is an idea that it would be a deterrent, but nonetheless, it is unique. It would expand the amount of information that's aggregated in one place about enforcement matters affecting non-bank organizations. And it certainly exceeds anything that's available in the public NMLS database for licensed non-bank organizations in the various categories. This is something that was proposed. Again, we expect further and additional announcements on this this year. And another topic, sort of breaking news as of a day or two ago, the non-bank registration of consumer terms and conditions. News of this began to leak towards the end of last year and is going into the beginning of this year, the first week of January, where the number of articles written about how this was in the works. And lo and behold, CFPB announced this week its proposal for a non-bank registration of consumer terms and conditions. Many see this as a follow-on to the prior and defeated attempt to prohibit arbitration provisions in consumer agreements for non-bank and bank financial services products. This in particular would cover non-bank activities, particularly with respect to covered supervised organizations by the CFPB. That would include debt collectors and small dollar lenders, of course, as well as others in the mortgage space and lending spaces, and would comprise a database of terms and conditions that would be required to be submitted. The contours of this are relatively basic. Certainly the implication is that there's a desire on the part of the Bureau to maybe shame organizations into not using certain provisions in their contracts, but at the same time to draw attention to them as well. And another topic, and this is one outside of the sort of the typical non-bank consumer financial services space, but certainly one that's gotten a lot of attention, the small business lending data collection. There is an expected final rule at some point, probably within the next 12 months. Announcement on this was originally done last year in terms of a lot of the substantive aspects of it. And then there was, in addition, comments that were received. Somewhat controversial, and also a sort of extension of the CFPB authority, but also required under Dodd-Frank. So not necessarily something that Congress didn't contemplate, but certainly something that gets into the realm of small business lending, which is not typically considered the purview of the CFPB. We also saw interest on automated valuation models last year and into this year. And we see that this is probably going to be a topic of interest in investigations and enforcement matters. Anywhere where there's automation, as mentioned before, there's the possibility of discrimination and the use of UDAP as suggested by the CFPB. But also anywhere where there's also options presented, not just with respect to pricing, but also even with respect to the contours of a particular financial services product. And so banking agencies, as well as also the CFPB, have shown an interest here. And there's, of course, the report from last year. that goes into great detail on some of the policy issues. And sort of last substantive rulemaking that we have our eyes on that we want to highlight is the FTC's telemarketing sales rule. One of the areas that has a number of actual specific prohibitions with respect to certain financial products and services, such as credit repair and advance fee loans, as well as also certain payments services. The TSR has been under sort of active rulemaking at the FTC now for some time, and the comment period closed mid last year, and this is one where sort of stay tuned, but there's a potential for additional announcements related to the telemarketing sales rule this year, so keep your eyes open for that. Now, at this point, we've talked a lot about consumer privacy and data security, and to get into some of the substance and outlook, turn it over to my colleague, Katie Marshall.
Thanks, Jonathan. Today, we'll cover a few key privacy-related developments related to the CFPB, states, and general federal proposals. Starting with the CFPB, this past August, the Bureau acted on a topic of key interest to privacy advocates, digital marketing, by issuing an interpretive rule limiting the applicability of the Consumer Financial Protection Act's time or space exception. As background, the CFPA imposes certain requirements on service providers, but exempts entities that solely offer or provide financial institutions with time or space for a financial ad from the definition of a service provider. However, this new rule clarifies that digital marketing providers that are materially involved in developing content strategy are not subject to this exception and may be service providers subject to the act as a result. As part of this rulemaking, the Bureau explained that providers that are involved in identifying or selecting prospective customers or how to place content to drive consumer engagement would typically not be subject to the time or space exception and may be service providers. This materially expands the scope of who may be subject to the CFPA and the CFPB's authority, as these types of providers may include some of the entities that typically operate in the advertising technology space. And given that there are requirements for banks and non-banks to conduct certain diligence related to service providers, as well as ongoing monitoring, it's important for entities engaging in digital marketing to take stock of the providers they use and see if any changes to current practices are needed. And moving to the next slide, I think we can actually skip the next slide as it relates to section 1033, which we discussed just a bit ago. So we'll move 2 slides ahead. Next one. Okay, great. So moving to state privacy rights. As you may know, there are 5 states that have comprehensive rights-based privacy laws that have already gone into effect this year or will go into effect. Both the new California and Virginia laws are in effect as of January 1st. Laws in Connecticut and Colorado will go into effect on July 1st. And finally, the new Utah law will go into effect at the end of the year. These laws all have exceptions relevant for financial institutions. However, the exceptions vary by state. For instance, there are some states that have entity-based exceptions and others that have data-based exceptions. And these exceptions are generally related to GLBA and FCRA. Importantly, the California and Colorado laws are data-based exceptions. So this means that financial institutions who are subject to GLBA, for instance, would have obligations under these laws for data that is not subject to the GLBA, assuming they meet the threshold requirements to be subject to these laws. And this type of data may include, for instance, data collected on a marketing website. More importantly, though, is the fact that the California Privacy Rights Act is an outlier and that it also applies to personal data collected about personnel and business contacts. So even if a financial institution does not collect any personal data about consumers that's subject to the law, it may well be subject to the law for its personnel and business contact data, assuming it meets, again, the requirements to be subject to the law. And the challenge with the CPRA is that it really wasn't written to address these types of data. So compliance can be challenging related to personnel and business contact data. While certain rights will need to be offered to these individuals, for instance, the good news is that the law will not be enforced until July 1st, which gives companies some time to determine how, for instance, you might respond to an access request sent in by an employee under the law. However, when the law is enforced, there will not be a cure period for alleged violations, which is very different than what we see under the other state privacy laws. So that just makes compliance by July 1st particularly important. Moving to the next slide. You may know that Congress took meaningful action related to privacy last session through the American Data Privacy and Protection Act, or the ADPPA. The bill was a real nail biter, and though it failed, it did come down to the wire. We do expect privacy, though, to continue to be a priority this session for at least some members of Congress based on public statements. However, given new leadership in the House and Senate, it is not a given that the ADPPA will be a starting point for discussions. So it's worth it to keep an eye out for different proposals that we'll see. And last, but certainly not least, the Federal Trade Commission began a rulemaking in August to regulate commercial surveillance and what they call lax data security. Both terms were defined in the advance notice of proposed rulemaking particularly broadly, and many commentators found the AMPR to be both overbroad and failing to meaningfully convey the FTC's direction for future rules. However, there should be more clarity when a notice of proposed rulemaking is eventually published, and this rulemaking is expected to take numerous years, so there'll be many opportunities to engage in the public comment process if you like. And I will hand it off to my colleague, Harley.
Thank you, Katie. So I'll be touching on a few cybersecurity regulatory developments here. And the first up is the Graham-Leach-Bliley update. The update to the safeguards rule will come into effect on June 9th. And these requirements were originally going to come into effect in December of 2022. But the Federal Trade Commission issued a 6-month extension because it was clear that not enough companies would be prepared on time, because a lot of these safeguards take a lot of time, require cooperation between the lawyers and security professionals to actually implement. And the big item here is that the Federal Trade Commission's rule requires non-banking financial institutions to implement these new data protection and access controls for customer information. The old rule required financial institutions to have safeguards to control any risks that were identified during a risk assessment. And the new rule requires specific safeguards. These include there are several of them, but they include monitoring authorized users, detecting unauthorized access, encrypting customer information that is transmitted externally, like to cloud servers or at rest, and multi-factor authentication, and several others. The new rule also has new testing requirements. So the old rule required regular testing of security safeguards, and the new rule now requires continuous monitoring or regular penetration testing and vulnerability assessments. So I'll just highlight 2 other items here as well. The new rule requires that financial institutions have written and more comprehensive cyber risk assessments and cyber incident response plans. These risk assessments and plans were always required, but now they have to be in writing, and there's a lot more that has to go into them in order to be compliant with the new rule. So the bottom line on this one is that financial institutions should reassess their organizational cybersecurity programs to ensure that they are in compliance with these requirements for customer information by June. As I mentioned, the safeguards do take a while to implement, and it's a collaboration with legal counsel and the security team, and we cannot count on another FTC extension. Next slide, please. So the next up is cyber incident reporting. And there are numerous incident reporting rules that are either proposed or coming into force soon, like over the next year, for the financial services sector. And here we're talking about requirements to report to the government when an institution experiences a significant service disruption or a network intrusion or unauthorized access to sensitive information. And in some cases, such as under the New York Division of Financial Services, there's also an obligation to report to regulators if a ransom is paid. So this is an additional affirmative obligation on top of the traditional personal data breach notification requirements. I won't go into all the regulations here. I'll let the slide speak for itself. But the big picture is that the financial service sector regulators are each getting on to this cyber incident reporting action. And unfortunately, the timelines for reporting, the triggers for reporting, and some of the other details are not all aligned across regulations. It is a patchwork and a quickly emerging patchwork. So financial services organizations should be aware that their reporting obligations no longer limited just to data breach, and they need to be ensured that they are capable of reporting their material cybersecurity attacks, and intrusions and exposures to regulators in the format and timeline required. I'll quickly note here as well that this list of financial services sector regulations does not include some of the other potentially relevant cyber incident reporting rules that are coming online in the next year. So for example, the Securities and Exchange Commission has a proposed rule for all publicly traded companies. The CISA has a rule for critical infrastructure sectors. And then there are also international incident reporting regulations emerging as well. So one way or another, many companies are going to be subject to these incident reporting requirements, and the patchwork is likely to perpetuate into the future. Next slide, please. So rounding out this trio of cybersecurity regulatory developments, we'll talk about the New York Department of Financial Services, which has proposed an update to its 2017 cybersecurity regulation. And this proposed rule would apply to the more than 16,000 or so financial institutions that are licensed or chartered by NYDFS. And just for purposes of a broad summary here, we can put this update into two buckets. The first is enhanced requirements for cybersecurity governance. So this includes getting the board and the CEO more involved in approving organizational cybersecurity policies and reviewing any sort of non-compliance or any material problems. The second bucket is requiring more security safeguards to protect against cyber attacks and disruptions. This includes things like phishing training, patch management, giving user accounts the least privilege necessary, managing passwords, multi-factor authentication, and several other items. So this is, like GLBA, a relatively prescriptive update. For Class A companies, or those that have more than $20 million in revenue, those companies, the proposed rule applies additional and more stringent cybersecurity safeguard requirements as well. So bottom line here, financial institutions should be aware that new NYDFS security requirements are likely to become final in the second half of 2023. And similar to the GLBA update we described earlier, organizations should be prepared to work with their counsel and their security teams to assess their organizational security programs to ensure they remain in compliance. And unless there are any cyber questions, I'll turn it over to supervision and enforcement.
Harley, thank you very much, and thank you, Katie. The consumer privacy and data security topic is one that is continuing to evolve, and particularly that safeguards rule development that you mentioned towards the end, Harley, is one that I think a lot of non-bank organizations certainly were scrambling towards, and is something that, you know, in the coming years will be also a topic of supervision and enforcement. And that brings us to this topic. So, you know, the supervision area of the CFPB is now fairly mature. We're over 8-9 years into examinations of non-bank organizations, and certainly some banks. It was old hat, where in some cases organizations have been under multiple examinations now. There's an exam cadence, but you also have a scenario where the CFPB has signaled that they want to expand into other non-bank categories that have traditionally been considered larger participants or falling under their jurisdiction by statute. And they've also continued to release a number of advisory opinions, and of course, obviously, the supervisory highlights, drawing attention to any number of potential legal issues that can be found in the examination setting, and oftentimes are resolved in an examination, whether or not the company might actually agree with the legal positions of the CFPB, simply due to efficiency and expediency. That being said, an increasing number of examinations that are happening behind the scenes, we are seeing the Bureau take more aggressive positions with respect to certain legal interpretations, ones that perhaps, if we're in the public, might be subject to litigation, but ultimately may never rise to that level, simply because in an examination and supervisory posture, organizations are dealing with the Bureau one-on-one, but also it's pre-enforcement oftentimes. And as a result of that, things can be resolved quietly, but ultimately maybe end up in a supervisory highlights or another context for information. Now, as supervision increases, we also expect to see the potential for enforcement to increase. And enforcement has also, by year to year, gone up and down. And there's not exactly a correlation between all of what's happening in the press and in the public statements of the Bureau and the numbers of enforcement actions that are public each year and taken. But in 2021, there were about 18, I believe, public enforcement actions. And year to year, we already have seen several more in 2022. So in 2023, we expect that the numbers will continue to rise. The enforcement focus by the Bureau continues to really be a smattering of issues, some big, some small. Certainly, Wells Fargo is a great example of companies with their back against the wall and perhaps repeat offender. On the other hand, you also have situations where you have issues that will either uncovered in exams or investigations where the topics are not cross-cutting. They might be very much unique to an organization. Now, what we also have seen from time to time is a increase in enforcement activity in terms of the pressure that the Bureau has been placing on organizations. As referenced earlier, though, there's a lot of companies now that, when an enforcement situation, are pushing back. We highlighted a couple of them. There's others as well, certainly even in the pre-public enforcement situation in terms of investigations. We see CIDs quite frequently that we can push back on. And certainly there are some examples publicly where CIDs have been pushed back on and are being litigated today. Really important development, something that perhaps wasn't in place just a couple of years ago in terms of the tools that companies have with respect to dealing with investigations and enforcement. Now, before we wrap up, just briefly on the state developments, there's a handful of topics that are relevant and we think interesting for the new year. In particular, the state AGs remain very active on consumer protection issues, particularly related to consumers in economic distress and vulnerable situations. And also we see an increase in state AG investigations morphing. What I mean by that is taking some of the learnings or missives and reminders of the CFPB to heart, including, for instance, like digital dark patterns and other issues that the CFPB has drawn attention to, and the FTC, and bringing those into the scope of investigations that may have been originally noticed on other topics. We also see the NMLS, for those involved in state licensing, continues to have hope and promise of increased efficiency and enhancement. The modernization process there continues. On substantive matters, they have been piloting the money services business, money transmitter application process with more uniformity and reciprocity across states. Not every organization chooses to take part in that, though. It's somewhat optional, but it is indicative of the type of efficiencies that we might see offered in the other licensing categories that are on the platform. And at this point, there's a vast number of licenses on the platform as compared to prior years, and certainly a very small number of categories, particularly really in the consumer finance space, that aren't on NMLS, and always the potential that they could be, but that's something that is certainly stay tuned for further developments. The California debt collection licensing law continues to kind of have some ups and downs in terms of its onboarding process and license applications, and there was a delay by a year. That's something that's going to come into scope this year, and we're going to start to probably see examinations in that area in the not too distant future. And already the legislatures are very busy this year. Certainly every year there's a flurry of legislative activity for usually about the first 6 months. There are proposals around certain financial services products. And in particular, we also know of some states that are considering adopting changes to their licensing statutes to carve out certain changes of control and other activities from the purview of the regulators' review and approval. But we still see those issues for licensees crop up in the situation of mergers and acquisitions and due diligences and other transactional matters, which are always active. But in particular, in this economy, there's a lot of activity around M&A work, a lot of stuff written on that topic. Licensing remains key there. So with that, we've gotten through all of our topics. We very much appreciate all of you joining us today. There is no shortage of consumer financial protection issues on the horizon. We've covered just a few of them in our curated talk today. Certainly, please stay tuned from us in terms of email alerts, digests, and additional webinars on future topics and expanding on the topics that we've provided today. Also, in addition, please feel free, if you haven't already, to subscribe to our CFS Digest and our alerts for financial services and payments topics. And also to, we very much appreciate the work of all the folks that helped put this on. Together, we've been able to present it, and we very much appreciate the audience too. So thank you to our panelists, everybody who was able to participate, Ellen, Andrew, Michael, Sarah, Len, Alex, Chris, Harley, and Katie, and also to our production team. In just a moment, we'll give the COE code one last time. But for those attending, we really appreciate you joining us today. Thank you. And our CLE code is CFS 2023.